Welcome to my channel. Today I'm going to deal with a special provision relating to retrenchment. It is retrenchment because I have already made videos on layoff, which you can search in YouTube description box. This is Industrial Disputes Act 1947, and here we are reading chapter 5b, and it was added in Industrial Dispute Act 1947 through amendment under Article 32 of the Constitution. This chapter deals with a special provision relating to layoff, retrenchment and closure, in certain establishments. Chapter 5b includes section 25k to section 25s. I have already made video on section 25m of the Industrial Dispute Act 1947, and we have to read definitions as well. But in this video, we're only concerned with retrenchment, so we're going to start our video. First of all, we have to learn the definition of retrenchment, and the important section here is section 2. It is of course under chapter 1, section preliminary. Chapter 1 is titled as preliminary, and under chapter 1 this is section 2, and we have to know what is the subsection. O. So this is what definition of retrenchment, section 2. O. Retrenchment means the termination. First of all, the first word used here is termination by the employer of the service of a workman. By the employer of the service of a workman. The employer terminates the service of a workman for any reason whatsoever, otherwise than as a punishment inflicted by way of disciplinary action, but does not include. It excludes punishment inflicted by way of disciplinary action, but does not include voluntary retirement, because voluntary retirement is not retrenchment. Retrenchment is termination of service by the termination by the employer of the service of a workman, and for any reason, but it excludes those kind of reason given here. Number 1 is punishment inflicted by way of disciplinary action. Second, voluntary retirement of the workman. If the workman voluntarily retires, then it will not amount to retrenchment, because retrenchment is wholly a different concept. Then B, retirement of the workman. Retirement also voluntary retirement of the workman reaching age of superannuation. On reaching the age of superannuation, if the contract of employment between the employer and the workman concerned contains stipulation, terms and condition means in that behalf. And termination of service of the workman as a result of on renewal of the contract of employment. The service may be terminated as a result of on renewal of the contract of employment between the employer and the workman concerned on its expiry, or of such contract being terminated under stipulated in this behalf contained thereon. Or C is termination of service of workman on ground of continued ill health. So we find several points. Let's see. In short, first of all, you need to remember only one word, that is termination. And termination of service of workman by the employer for any reason, but the reason is not number 1, punishment inflicted by way of disciplinary action. Number 2, voluntary retirement. Number 3, retirement of workman at a particular age. Number 5, termination of service as a result of renewal. And number 6, termination of service of a workman on ground of continued ill health. These things are excluded. Now we are going to read special provisions relating to retrenchment, which is provided under chapter 5b of the Industrial Disputes Act 1947, and here the important relevant section we are going to read is section 25n, and section 25m deals with a special provision relating to layoff, which I have already made a video on it. So this is section 25n, condition precedent to retrenchment of workmen. Condition precedent meant certain essential element or requirement or conditions or preconditions before retrenchment. So no workman employed in an industrial establishment to which the chapter applies who has been in continuous service for not less than 1 year under an employer shall be retrenched by that employer until is only in these conditions it can be done. So no workman employed in an industrial establishment to which this chapter applies who has been continuous service for not less than 1 year. The workman is in continuous service of not less than 1 year. That means 1 year or more than 1 year under an employer shall be retrenched by that employer until the workman has given 3 months notice. The procedure for retrenchment is that the workman must be given 3 months notice in writing, advance notice in writing, indicating the reasons, because it's important for the workman to know the reason of retrenchment. For retrenchment, and the period of notice has expired, and after the expiration of the period of notice, or the workman has been paid in lieu of just notice wages for the period of the notice, and the workman has been paid in lieu of just notice wages for the period of the notice. And B, the prior permission of the appropriate government or such authority as may be specified by that government by notification in the official gazette. We can see in other words, prior permission of appropriate government or a specified authority has been obtained on an application made in this behalf. So by an application, the prior permission of the appropriate government or specified authority is required. Along with this, the first requirement is that the person must be served 3 months advance notice in writing, and the notice must contain the reason for retrenchment. And the period of notice has expired, or the workman has been paid in lieu of such notice wages for the period of the notice. So here we find what? 2 requirements: 3 months advance notice in writing stating the reason of retrenchment, and prior permission of either the central government, appropriate government includes central government as well as state government or specified authority. Then subsection 2. An application for permission under subsection 1 shall be made by the employer in the prescribed manner. It shall be made by, of course, the employer. Application to whom? Appropriate government, which may include central government as well as state government, and specified authority. And it must be made in the prescribed manner, stating clearly the reasons for retrenchment, because it's very important. And a copy of such application shall be served simultaneously to the workman concerned in the prescribed manner. So there must be an application. The application must be made by the employer, and the order shall be obtained by prior permission shall be obtained either by appropriate government or any other specified authority. And after the copy of such application, the copy of such application shall be served to the workman as well, and the application must contain the reasons of retrenchment. This is the lawful procedure. Then comes subsection 3, where an application for permission under subsection 1 has been made. The appropriate government or the specified authority, after making just inquiries, and now it is the duty of the appropriate government or specified authority to make inquiry as if things fit, and after giving a reasonable opportunity of being heard to both the employer and the workman. The employer and the workman both are entitled to the reasonable opportunity of being heard, because this is the very rule of natural justice. The workman concerned and the person interested in just retrenchment, and not only the employer or the workman but any other kinds of person who may be interested in the retrenchment, must be given a reasonable opportunity of being heard, and it shall be done by the appropriate government or specified authority after making just inquiry as it deems fit. Consider interest may have regard to the genuineness and adequacy of the reasons. As we have already found in an application made by the employer, he must state the reasons for retrenchment, and it is the duty of the appropriate government or specified authority to check the genuineness and adequacy of the reasons, whether the reasons are genuine, whether it is adequate or required as to the time and fact and circumstances of the case. Stated by the employer, the interest, because it's important. The reason must be genuine and adequate. The interest of the workman and all other relevant factors, and also the interest of the workman, whether his rights and interests are violated or not, whether it is needed, adequate or genuine for considering the facts and circumstances in the case, and all other relevant factors, by order for reasons to be recorded in writing, grant or refuse. And after doing so, all these things, the appropriate government or specified authority has 2 kinds of options or powers. They can make an order. The order may be either to grant as regards to granting the such permission or refuse. The order may be as regards to through the order they can either grant the permission or refuse the permission. And copy of choice order either regarding granting the permission or refusing shall be communicated to both the person, employer and workman. Then, where an application for permission has been made under subsection 1 and the appropriate government or the specified authority does not communicate the order granting or refusing to grant permission, if in case, as we have seen in subsection 3, that they must communicate the order, but if they does not communicate, if the specified appropriate government and specified authority does not communicate the order granting or refusing to grant permission to the employer within a period of 60 days. The time period here, 60 days means 2 months. The date on which such application is made, and it shall be commenced from the date in which such application is made. The application shall be made by the employer. So application is made. The permission applied for shall be deemed to have been granted on the expiration of the said period of the 60 days. Deemed to means it a kind of fictitious thing. It is a kind of presumption or assumptions. So that means after expiration of 60 days, they shall deem to have granted on the expiration of the said period of 60 days. The permission shall be deemed to have been granted. After is an order of the appropriate government or a specified authority granting or refusing to grant permission shall, subject to the provisions of subsection 6, be final, binding on all the parties concerned, and shall remain in force for 1 year from the date of such order. So this is the legal effect of the order as provided under subsection 5. But it is of course subject to subsection 6. How? Subsection 6 provides that the appropriate government or a specified authority may either on its own motion or application made by the employer or any workman review its order granting or refusing to grant. It is a review. Its order granting or refusing to grant permission under subsection 3 or refer the matter as the case may be or cause is to be referred to the tribunal for adjudication, provided that where a reference has been made to tribunal under this subsection, it shall pass an award within a period of 30 days from the date of just reference. So that means this order is subject to review. It may be done either on the appropriate government or specified authority's own motion or on application made by the employer or the workman. That means the employer and the workman has power to review the order, and for this purpose they have to make an application, and also the appropriate government and specified authorities also has power of review. And also apart from this, the tribunal also has power to review it or granting or refusing to grant prior permission under subsection 3 or refer the matter as the case may be cause it to be referred to a tribunal for adjudication, and it can be referred to a tribunal as well. Provided that a reference has been made to the tribunal under this subsection, it shall pass an award within period of 30 days. And what is the responsibility or duty of the tribunal? Within 30 days, it shall pass an award 30 days from the date of such reference. 30 days is given to the tribunal for passing any kind of award or for adjudicating disputes. Subsection 7, where no application for permission under subsection 1 is made, or where the permission for any retrenchment has been refused, such retrenchment shall be deemed to be illegal. On what grounds it shall be deemed to be illegal? If no application for permission has been made, but the employer are retrenched, or if they refused, the appropriate authority, specified government refused to grant permission for such retrenchment, then these kind of things will be deemed illegal. From the date on which the notice of retrenchment was given to the workman, and the workman shall be entitled to all the benefits under any law for a time being in force, as if no notice has been given to him. Because already if it is illegal, then it has no legal force, it is not binding, and the workman shall be entitled to all the benefits. Such exceptional circumstances as accident, but exceptions is also there. As accident in the establishment or that of the employer, it may be accident because it's a kind of unforeseen contingency or a or a situation beyond the control of the employer or employee and or establishment or that of the employer or the like, it is necessary so to do by order direct the provision of subsection 1 shall not apply to in relation to such establishment for such period as may be specified in the order. In those cases the prior permission is not needed because this is the situation, emergency situation. Then comes subsection 9, where the permission for retrenchment has been granted under subsection 3 or where permission for retrenchment is deemed to be granted under subsection 4. Every workman who is employed in the establishment immediately before the date of application for permission under this section shall be entitled to receive before the date of application for permission under this section shall be entitled to receive at the time of retrenchment compensation which shall be equivalent to 15 days average pay for every completed year of continuous service or any part thereof in excess of 6 months. So the infirmity in retrenchment by reference to section 25 and cannot be ventured to be found out without laying factual foundation attracting applicability of the provision. Now it is only the before the date of application for permission under this section shall be entitled to receive at the time of retrenchment compensation which shall be equivalent to 15 days average pay. So now various cases are there regarding section 25N. Workmen of Meenakshi Mills Ltd, etc. versus Meenakshi Mills Ltd. So this is a industrial establishment. Meenakshi Mills Ltd, workmen of Meenakshi Mills Ltd, etc. versus Meenakshi Mills Ltd. And another, the Supreme Court held that Section 29 Act of the Act as constitutionally valid on the ground that, what is the ground of such validity? That the restrictions imposed on the right of employer to retrench workmen is in interest of the general public interest. This is the ground. It does not infringe Article 19(1)(g) of the Constitution and duty to pass a speaking order and affording opportunity to the parties concerned to judicial power while functioning under subsection 2 of Section 25N, and hence no appeal lies to the Supreme Court against an order passed under subsection 2 of Section 25N because it is constitutionally valid, a kind of constitutionally valid on the ground that it imposed restrictions, of course reasonable restrictions, on the right of the employer because employer also enjoys certain rights to retrench workmen is in interest of general public and does not infringe Article 19(1)(g) of the Constitution, and duty to pass a speaking order and affording opportunity to the parties concerned with a judicial power while functioning under subsection 2 of Section 25N, and hence no appeal lies to a Supreme Court against an order passed under subsection 2 of Section 25N. This is very easy, and the case is workmen of Meenakshi Mills Ltd, MM, workmen, and this is plural of this name is same with this name, Meenakshi M Mills Ltd. Very easy. Then another case is Uttaranchal Forest Development Corporation and another was a Jabbar Singh and others. The service of the respondent workmen were retrenched by notice in compliance with Section 6N of the UP Industrial Disputes Act 1947. It is Industrial Disputes Act applicable to UP. That's why UP Industrial Disputes Act 1947. The year is same. Labor Court gave in. It is the Labor Court. Labor Court gave an award holding the retrenchment as valid. The award was challenged in the High Court, and the court directed reinstatement with back wages. Reinstatement along with the back wages. The question for consideration was whether the corporation was an industrial establishment within Section 25L of the Industrial Disputes Act 1947, and if so, whether the retrenchment was not valid for non-compliance of Section 25N of the Industrial Disputes Act 1947. So, what was the observation of the Supreme Court? The Supreme Court observed that the process of cutting trees by axe and changing the shape by saw and conversion of trees into logs for purpose of sale and disposal fell within the scope of manufacturing process. Because it includes several stages like cutting trees by axe, then changing the shape by saw and conversion of trees into logs for what is the purpose here for sale and disposal fell within the scope of manufacturing process under Section 2K of the Factories Act 1948. Factories Act is also another legislation. The establishment of appellant was therefore held to be an industrial establishment under Section 25L of the Industrial Disputes Act 1947, and Section 25N was applicable. The appellant did not comply with the two requirements of Section 25N appellant of the Industrial Disputes Act 1947, namely given 3 months notice or wages in lieu of notice. Two options are there, either to give 3 months notice or wages in lieu of notice. If notice is not given, and taking permission from the appropriate government. The retrenchment notice was therefore illegal, and workmen were held entitled to be reinstatement with full back wages and continuity of service. Many benefits. First of all, reinstatement, then full back wages, previous wages, plus continuity of service. They shall not be terminated from service unreasonably. You can see here again, Uttaranchal Forest Development Corporation, Uttaranchal Forest, because it includes tree development corporation, and another versus Jabbar Singh and others. This is the respondent, Jabbar Singh and others. Jabbar and Singh. Services of the respondent workmen were retrenched by notice in compliance with Section 6N of the Industrial Disputes Act 1947. Labor Court gave an award holding the retrenchment. Labor Court and valid. This is the Labor Court's award. But then again, High Court will play the role. High Court and the Court directed reinstatement with back wages. The question for consideration was, what was the question for consideration before the court? Was whether the corporation was an industrial establishment within Section 25L of the Industrial Disputes Act 1947. And if so, whether the retrenchment was not valid for non-compliance of Section 25N of the Industrial Disputes Act 1947. Okay, so there are two questions. Number one question. Question number one. Whether the corporation was an industrial establishment within Section 25L of the Industrial Disputes Act. The important section here is two sections, Section 25L and Section 25N. And if so, whether the retrenchment was not valid for non-compliance of Section 25N of the Industrial Disputes Act. So obvious answer is that, of course, the establishment was an industrial. The corporation was an industrial establishment. Why? What is the reason for being so? Here's the answer of first question. The Supreme Court observed that the process of cutting trees, number one, cutting trees by axe, and changing the shapes by saw, and conversion of trees into logs for purpose of sale and disposal, within the scope of manufacturing process. It is the manufacturing process enhanced Section 2K of the Factories Act, manufacturing process under Section 2K of the Factories Act. That's why it is an industrial establishment. Then what is the second question? The establishment of appellant was therefore held to be an industrial establishment under Section 25L as well, because it is the manufacturing process under the Factories Act 1948 of the Industrial Disputes. Okay, that's why it is an industrial establishment under Section 25L of the Industrial Disputes Act 1947, and Section 25(9) was applicable. Why Section 25? Sorry, not 9. And why Section 25N was applicable? Because it is an industrial dispute under Section 25L of the Industrial Disputes Act 1947. Then, whether the retrenchment was valid or invalid. This was the second question. Let's begin. If so, whether the retrenchment was not valid for non-compliance of Section 25N of the Industrial Disputes Act 1947, not valid, because it did not comply with the provisions provided under Section 25N of the legislation, Industrial Disputes Act 1947. So, here's the answer. The appellant did not comply with the two requirements of Section 25(9). Two requirements. What are those requirements? Again, 9. Section 25N of the Industrial Disputes Act 1947, namely giving 3 months notice or wages in lieu of notice. And 2, taking permission from the appropriate government. Neither they gave notice nor they took permission from the appropriate government, but they retrenched the workmen. The retrenchment notice was therefore illegal. It was illegal, and the workmen were entitled to be reinstatement. Number 1, reinstatement. They are entitled to the work reinstatement with full back wages, and the wages which they are not entitled during the time of retrenchment, plus continuity of service. They shall be continued in their work service. So thank you. Thanks for watching.